Melissa Murray is a professor of law at NYU who specializes in family and constitutional law. Earlier, I spoke with her about marriage law in the U.S. and why it has been very difficult for advocates to make a change on a federal level. When you look at the evolution of marriage and what's legally allowed and isn't, how has that evolved over the years?
Well, marriage is really different. What we know today of marriage is really different than what was expected even a generation ago. Common law, marriage was a way to pass on property, maybe to make alliances between different clans in order to expand the holding of property, or to make different alliances to prevent other groups from coming in and encroaching upon a particular area. So it was much more economic in nature, much more practical, and it's really evolved to be something that's more of a companionate institution where there's an expectation of love and fidelity and trust. There were much more practical concerns about marriage a generation or two ago.
What's really the argument for keeping marriage laws at a state level instead of a federal mandate?
Well, part of it is a constitutional argument. So the Constitution is a document that's aimed at limiting the powers of the federal government, and in limiting the federal government, providing certain powers for state governments and ostensibly the people who are closer to the states than they are necessarily to the federal government. So when the Constitution was drafted, there are certain things that they don't expect the federal government to be involved in. Education might be one of those things. Certainly marriage has traditionally been one of those things. Criminal laws have been one of those things. And a lot of that's changed over the years. Obviously, there's much more federal intervention in education, even as it remains a traditional state concern. There is much more federal criminal law than there was at the founding. But marriage still seems to be sort of set off as this place where there's incredible diversity at the state level and a real resistance to federal intervention.
When you talk about marriage, in some cases, judges have used marriage as a punishment. Can you explain that?
Well, so this is something I've written a lot about. I think it's absolutely fascinating. I think to understand the idea of marriage as punishment, you really have to understand the function that marriage played in the past and continues to play in the future in a lot of ways. So during the 1800s and 1900s, marriage was all that a woman could hope for if she wanted to provide for herself. There were not a lot of options for women to work, certainly not options that could be really well paying and you could support yourself honestly on that kind of work. So one court says it quite explicitly: marriage is but a chapter in a man's life, but for a woman, it is the epic of her life. This is the most important economic decision a woman will make for herself, whether and with whom she will marry. And so this idea of marriage as punishment, you have to start from that place. So there were a number of states, and in the 1800s, the early 1900s, about 38 American jurisdictions, in fact, that had this crime on the books called seduction. And seduction was meant to kind of bridge the distance between consensual sex outside of marriage, which was a crime, and a kind of coercive sex outside of marriage that wasn't quite rape because maybe you knew him, but it definitely wasn't quite consensual because of certain aspects of it. And in particular, they imagined that men would coerce women into sex by promising them that they would eventually get married. Like, you know, let's just do this one time, you know I'm going to marry you. But then he never married her. And it was called seduction. And so you had all of these cases in the 1900s where men would be hauled into court by the fathers or brothers of women that they'd had sex with, and the charge would be seduction. You defiled my daughter, you defiled my sister by telling her you were going to marry her, and then you never did. And the judge would hear these charges, and then he would say to the defendant, do you want to stand to these charges, or do you want to marry her?
Wow.
And if he said, yes, I will marry her, suddenly everything changed and that courtroom was transformed from a criminal trial to a marriage. And the judge actually performed a marriage of the defendant and his erstwhile victim. But this was the best part. Nobody thought that the defendant was getting away with it, nor was his victim getting away with anything. She too had committed a crime by having sex outside of marriage. And so it was understood that marriage was not getting out of it. It was actually a different kind of punishment, one in which the couple would be transformed from sexual outlaws into respectable in-laws, right? So marriage was a disciplining institution. Once married, he would be required to be a husband. He would be sober, and he would provide for the family and be there for her. And if he didn't, if he cheated on her, if he stepped out on her, if he left her or abandoned her, they could simply resume the prosecution for seduction.